Yes, I saw that. Actually, it's not quite fun, I think, because we're going to add a counter. We are alleging that the allegation is fraud is full by bribery. Yes, I saw that. So that's amusing. The servant posse should use the other. The principal villain who George will get over blessing body. He's going to give me all sorts of problems. So what is it? So they're saying no, they're saying that we fraudulently inflated the assumptions we inflated.
All right.
Well, we were going to move on to the issue of whether, if the court has jurisdiction, it should decline to exercise that jurisdiction. And that also engages and it aligns with the next issue in our roadmap, in our skeleton, namely, does the doctrine of state immunity apply within the DIFC? Because if so, and this court finds it has jurisdiction to determine the nature and extent of immunity, it is the KRG submission that the doctrine of state immunity is applicable to the DIFC, and therefore the DIFC should decline to exercise its jurisdiction. So, we submit that it is frankly absurd to suggest that there is no doctrine of state immunity in the UAE and therefore none in the DIFC. We will, if we may, look at the authorities, I say in inverted commas, for the proposition that the claimants rely on in their skeleton, in the order in which they appear in that skeleton. If you'd be kind enough, my Lord, to turn to bundle G3, the first is at tab 74. This is a section from Chambers Global Practice Guides, Banking and Finance, UAE Law and Practice, written by a law firm in 2016. And the section relied upon by the claimants in their submissions appears on internal page number 13. The numbering is the bottom right hand corner. And it's a passage just below the centre of the page, where it is stated, with regard to waiver of immunity, the doctrine of sovereign immunity does not expressly apply under UAE law. Foreign governments are therefore not immune from being the subject of a lawsuit in the UAE. We have three comments on that. First of all, we note that none of the authors of this article is in fact an Emirati advocate. Secondly, no underlying authority is cited for the propositions. And thirdly, the passage itself contains a howling non sequitur. Even if it is true that the doctrine of sovereign immunity does not expressly apply under UAE law, it does not follow that foreign governments are not immune from suit. The doctrine did not expressly form part of English law before the Sovereign Immunity Act. The next authority relied upon is at tab G3, tab 82, and that is the February 2013 arbitration guide published by the International Bar Association. At this time, sorry, forgive me, the next one in order in other defence submissions is in tab 81. I'm so sorry. And that is the Global Arbitration Review UAE Litigation Review of 2017. And on this occasion, in fact, the author is a distinguished Emirati advocate, Mr. Hassan Arab, who is head of litigation at Messrs. Al-Tamimi. And if one turns to internal page 5, under section 10, heading Sovereign Immunity, it's a question and answer. Which entities are immune from being sued in your jurisdiction? In what circumstances can creditors enforce a court judgment or arbitral award against a sovereign or a state entity? Answer. Article 41 of the UAE Constitution provides that every person shall have the right to submit complaints to the competent authorities, including the judicial authorities, concerning the abuse or infringement of rights and freedoms. As such, no entities are immune from being sued in the UAE. However, there are specific procedures that may have to be followed to sue certain governmental entities. In fact, of course, Article 41 of the UAE Constitution has nothing to do with foreign sovereign immunity. I took my Lord to it earlier this morning, I won't do it again. but just for the note, it is at bundle 21, tab 23. And Article 41 concerns the enforcement of rights against the UAE government. And so this is not a helpful passage to the court. The third in order is behind tab 83, which was the one I took the court to a moment ago by mistake. That is the arbitration guide for the IBA, and the relevant page is at
tab 82.
Tab 82. I'm so sorry. Did I not give the tab? And the relevant page is internal page 18 under heading Roman 14, sovereign immunity. Do state parties enjoy immunity in your jurisdiction, under what conditions? And the passage relied upon is the one sentence: UAE law does not expressly provide that foreign state parties enjoy immunity. Again, use of the word expressly, although it doesn't make the same non sequitur as in the first passage, and that is exceptional. And then finally, tab 80, which is the global arbitration guide, again to commercial arbitration this time, and the sorry, I've lost my flag, if you'll forgive me for a moment. Thank you very much. Yes, thank you very much. It's at internal page 17, paragraph 46. To what extent might a state or state entity successfully raise a defence of state or sovereign immunity at the enforcement stage? And it said there is no state immunity in either the DIFC or the UAE both for foreign states and domestic emirates. Some emirates do require that notice be served on their legal affairs departments before commencing arbitration, and consent for the arbitration to proceed is routinely granted. Now, I did have the pleasure of leading the learned author quite recently in an arbitration before Sir Anthony Coleman, but he is not an Emirati advocate, and frankly it is my submission that he is simply wrong. That there is
Who is the author?
A gentleman called Robert Carollusley, who was at that time at Altamimi Company on the next page, who's an English barrister.
I have come across the judgment.
As I say, although I know him very well, I disagree with what he says forensically. So we disagree. He submit is wrong. To contrast that, we have the view of a professor at the Faculty of Law at Sharjah University, Professor Abdul Hamid Turki, in a publication, Al-Wasit in the Interpretation of the Emirati Civil Procedure Law, and you'll find that at tab 73. In English translation and indeed in the original Arabic, I think. Professor Turki says this: the lawsuits filed against persons enjoying judicial immunity. The international law rules grant a judicial immunity to international legal personalities, states, organisations and international bodies, to their authorised members, presidents and diplomatic representatives, before the foreign judiciary. Thus, the jurisdiction of the foreign judiciary shall not include them. That immunity includes the litigation stage and the execution stage, In view of the aforementioned, the presidents of foreign states, the diplomatic envoys, and the employees at international organizations shall enjoy the international judicial immunity in civil, criminal, and administrative matters. We say his view reflects the classic international consensus and is undoubtedly correct. The consensus we also see from the decision of the International Court of Justice in the case jurisdictional immunities of the state, Germany against Italy with Greece intervening, which my Lord will find at bundle G2, tab 53, paragraph 56.
Short on reasoning, any of these
Yes.
articles, or
Yes. Although we do say that, as I said, Professor Turkey's view in that textbook does reflect very much the international thinking on it. And if we see what the International Court of Justice says at paragraph 56, although there has been much debate regarding the origins of state immunity and the identification of the principles underlying state immunity in the past, the International Law Commission concluded in 1980 that the rule of state immunity had been, quote, adopted as a general rule of customary international law, solidly footed in the current practice of states. That conclusion was based upon an extensive survey of state practice, and in the opinion of the court is confirmed by the record of national legislation, judicial decisions, assertions of a right to immunity, and comments of states on what became the United Nations Convention. That practice shows that, whether in claiming immunity for themselves or according it to others, states generally proceed on the basis that there is a right to immunity under international law, together with a corresponding obligation on the part of other states to respect and give effect to that immunity. The fact is that the claimants have not been able to point to a single developed legal system that does not acknowledge the doctrine of state immunity. We say that the sources of the doctrine in the DIFC are common laws adopted in the DIFC, public international law, and the public policy or public order of the UAE. And indeed, the public policy of the UAE determines whether, and if so how, the doctrine will be applied under both common law and public international law. We've already explained how we say the DIFC follows common law. We say that state immunity is an established feature of the common law, and there is no reason why the DIFC should not incorporate it in its version of common law, and indeed every reason why it should do so. If I can take a brief canter through the English common law prior to the Act and then briefly subsequent to it. I know my Lord is very familiar, and I won't trespass on his patience too much with this, but if we could take up bundle G3 and begin at tab 78. We're back with Dicey and Morris, and this time at the first page behind the tab, where Dicey says the basic principle confirmed by Section 1 of the 78 Act is that a foreign state is immune from the jurisdiction of the courts in the United Kingdom. In the words of Lord Atkin, described by Lord Denning as the classic restatement, the courts of a country will not implead a foreign sovereign, that is, they will not, by their process, make him against his will a party to legal proceedings, whether the proceedings involve process against his person or seek to recover from him specific property or damages. The immunity is derived ultimately from the rules of public international law and from the maxim of that law, par imparem non habet imperium. The relevant rules became part of the English common law, now reflected in the State Immunity Act. And indeed, the common law really on the subject began with the Parliament Belge case, which my Lord will find at tab 65 in this bundle. And I should just, if I may, like take the court to page 214 of the report in Parliament Belge. So it's a decision of the English Court of Appeal. And at the bottom of page 214, the principle to be deduced from all these cases is that as a consequence of the absolute independence of every sovereign authority and of the international comity which induces every sovereign state to respect the independence and dignity of every other sovereign state, each and every one declines to exercise by means of its courts any of its territorial jurisdiction over the person of any sovereign or ambassador of any other state, or over the public property of any state which is destined to public use, or over the property of any ambassador, though such sovereign ambassador or property be within its territory, and therefore but for the common agreement subject to its jurisdiction. So this was an expression of the absolute rule. We then move forward to the Christina, which you find at tab 70, and this is a decision of the House of Lords, and where the classic statement attributed to Lord Atkin comes from, that was referred to in Dicey. May I just take you to the speech of Lord Atkin at page 493 at the bottom of the page. I agree with my noble and learned friend on the Woolsack that in the present case not only were the Spanish government in fact impleaded, but they were intended to be so impleaded. Further, the order sought in the present case would necessarily displace the de facto possession of the Spanish government. I agree with my noble and learned friend that the doctrine of immunity of the property of a foreign sovereign dedicated to public uses includes the case of actual possession for public use, because this was a vessel that had been actually had been seized by the Spanish government. In view, the case clearly comes within the principles laid down in the Parliament Belge. But, my lords, I have some doubt whether the proposition that the foreign sovereign state cannot be impleaded is an absolute one, the real criterion being the nature of the remedy sought. So this is perhaps the beginning of the restrictive view. But if I could just pass on in the speeches to that of Lord Macmillan at page 497, and he says this: but just as individuals living in a community find it expedient to submit to some diminution of their freedom of actions in favour of their fellow citizens, so also the sovereign states which constitute the community of nations have been led by courtesy as well as by self-interest to waive in favour of each other certain of their sovereign rights. The extent of these mutual concessions and their recognition is primarily a matter of international, not domestic law, and as much necessarily be the case as with all international law, which has neither tribunals nor legislatures to define its principles with binding authority, there may be considerable divergence of view and of practice among nations. Hence, when questions involving international law arise in the domestic courts of a state, problems of great difficulty and gravity may emerge. Although, of course, I say that that's perhaps of particular importance in the context of the situation that this court finds itself in. And if we then move to the statement of the restrictive view, which now is the statement of English common law immediately prior to the Act, we find that in the very well-known Trentex case, and I'm sure my Lord is extremely familiar with, and Lord Denning's judgment in that case. I won't read it extensively. Can I just take you to page 552? Well, actually, may I begin reading at least begin the reference at 552. As I say, I'm not going to read it in its entirety. May I invite my Lord, perhaps at his leisure, to read 552F to H, where Lord Denning sets out what he calls the general procedural picture. He then goes on to look at what is the place of international law in the English system, and comes to conclusion at page 554, letter G, the rules of international law have changed and do change, and that the courts give effect to change without any act of Parliament. It follows, to my mind, inexorably that rules of international law existing from time to time do form part of English law. It follows, too, that a decision of this court as to what was international law 50 or 60 years ago is not binding. International law knows no rule of stare decisis. In this court today, if this court today is satisfied that the rule of international law on a subject has changed from what it was 50 or 60 years ago, it can give effect to that change. He then went on to consider the doctrine of absolute immunity as expressed in Parliament Belge, and he quoted from Lord Atkin's speech in the Christina. And then just at letter F, he said many countries have now departed from the rule of absolute immunity, so many have departed that it can no longer be considered a rule of international law. It has been replaced by a doctrine of restrictive immunity. This doctrine gives immunity to acts of a governmental nature, described in Latin as iure imperii, but no immunity to acts of a commercial nature, iure gestionis. And so, my lord, that gave rise in English law to the adoption of the restricted theory of immunity. And then if I just finish this very, very quick review of the English law with the I Congresso case, which I'm afraid one has to go to bundle G2 for, and it's bundle G2, tab 56. Again, a decision of the House of Lords after the passing of the Act in the hearing was in 1981, it was reported in 1983. And I'd just like to take you to part of Lord Wilberforce's speech, which begins on page 262, letter C. It says, "It is necessary to start from first principles. The basis upon which one state is considered to be immune from the territorial jurisdiction of the courts of another is that it is that of par imparem, which effectively means that the sovereign or governmental act of one state are not matters upon which the courts of another state will adjudicate. The relevant exceptional limitation which has been engrafted upon the principle of immunity states under the so-called restrictive theory arises from the willingness of states to enter into commercial or other private law transactions with individuals. It appears to have two main foundations. A, it is necessary in the interest of justice to individuals having such transactions with states to allow them to bring such transactions before the court. B, to require a state to answer a claim based upon such transactions that does not involve a challenge to or inquire into any act of sovereignty or governmental act of state. It is an accepted phrase whether a threat to the dignity of the state nor any interference with its sovereign function." So, my lord, as I say, a very quick canter through what was the English common law prior to the enactment of the State Immunity Act. We've already noted that Lord Bingham stated in Jones and Saudi Arabia that Article 5 of the UN Convention contains a basic rule of state immunity from jurisdiction of the courts of another state, and he cited there that article which says that a state enjoys immunity in respect of itself and its property from the jurisdiction of the courts of another state, subject to the provisions of the present convention. And then the convention, of course, also included some exceptions. So we say that we have established in our submission that the KRG is a sovereign entity. We submit that the DFIFC should follow English common law and find that the KRG is entitled to state immunity. We've spoken quite a lot about international law, but we say that there is a helpful summary in Lady Fox's book, which can be found at tab 85 of bundle G3. Sorry, my lord, forgive me, may I come back to Lady Fox's book at the moment? Otherwise it may take too much time, I think, and I'm conscious of time slipping away a little.
What's the point you were going to make?
Only really by way of summary and helpful summary, my lord, of the position under international law. But I can make the submission later on.
All right.
When we come to the waiver question, which I really must deal with in some detail. So
Okay.
I'm going to move on to that, if I may. Because we say that KRG is entitled to state immunity as a matter of public international law. My lord, these references are in our skeleton in any event, but we say that cannot be doubted. So while UAE law contains no express legislation dealing with questions of foreign states' immunity, we've seen Professor Turkey's views, and he speaks of international rules, and indeed that would refer, we would say, to the Riyadh Convention. And I highlighted to my lord when I was going through the Riyadh Convention that one does see immunity in the Riyadh Convention at Article 25. In relation to the execution of judgments. And so this is an expression within an international convention to which the UAE is a party of immunity from execution. And so underpins the reasoning of Professor Turkey. As I mentioned before, the UAE, in common with most, if not all, of the Gulf states, often seeks guidance and elucidation of its laws from the decisions of the Egyptian courts. Again, my lord, we've set those out in our skeleton. The references are there. In the interest of time, and indeed the translations are not the easiest of reading in some cases. I won't read them out, but my lord, they are set out verbatim in our skeleton. And what is clear is that the Egyptian Court of Cassation has applied the doctrine of state immunity in Egypt, notwithstanding that it does not form part of an express law. But it has applied it as a matter of international law, and also that the Egyptians apply a restrictive theory of state immunity. The advice from our Emirati co-counsel and our submission is that the UAE is likely to follow Egyptian authority and recognise sovereign immunity. Whether the absolute or restrictive variety, we cannot say at the moment, but it probably doesn't matter in the context of this case, given the findings of Mr. Justice Burton, because Mr. Justice Burton, and we adopt his reasoning, found that a long-term disposition of natural resources was an exercise of sovereign activity. And indeed, if one is trying to second-guess the attitude that the UAE may take, then one may hazard a guess that courts in an oil-producing country might consider that such contracts, concerning its natural resources, were indeed sovereign rather than simply commercial in nature. But what follows from the foregoing analysis is the conclusion that it was wholly wrong on the part of the claimants to inform this court on the ex parte application that there is no doctrine of state immunity in the DIFC. The overwhelming likelihood is that there is a doctrine of state immunity, and it has to be expressed in terms of likelihood, because the only way one can be certain and indeed understand the nature and limits of the doctrine is if the UAE courts determine it, and given that the doctrine is based in international law, but customary international law, and more specifically embodied in treaties, it is for the Union Supreme Court to state the law for the whole of the UAE. It is not, we respectfully submit, for the DIFC merely to state the law in the DIFC. The claimants suggest that all of the UAE courts are competent to decide the issues of state immunity, and, I quote, do so. That seems rather contrary to its case that there is no doctrine of state immunity if those courts are actually enforcing it. It suggests that if that were not the case, any claim to state immunity, the claimants suggest that if that were not the case, any claim to state immunity would trigger a reference to the Union Supreme Court. We say that is wrong, since if the Union Supreme Court has decided the issue, it will be decided once and for all for the entirety of the country, and it will be binding upon all. We have noted that we draw a parallel with the situation in which the Hong Kong Court of Final Appeal found itself in the Congo case. And again, in the interest of time, I'd like to take it, if I may, my Lord, quite quickly, just to draw your attention to some passages of the judgment in that case, which I haven't referred to before. So if my Lord would be kind enough to take up bundle G2, tab 42. And to turn to internal page 140, my Lord, again, forgive me, I'm going to note the paragraphs rather than read them out in the interest of time, and just, if my Lordship will not mind, tell my Lord the points I'm making on those paragraphs. So, at page 140 begins an analysis of the meaning of foreign affairs and the acts of state doctrine. If then one runs forward to paragraphs 3, 4, 8 through to paragraphs 3, 5, 5, the conclusion is that the determination of immunity, sovereign immunity, and indeed its extent is a matter for the CPG, the Central People's Government. And that is the organ of state that was, when properly viewed, charged with determining issues of foreign affairs, and it followed from that that the Hong Kong courts did not have jurisdiction to determine what the policy and ultimately the law of immunity was. And we say that is exactly the same position under the UAE constitution that this court finds itself in. I would then ask my Lord to run forward to paragraph 361 on page 145, and the court identifies there questions relating, first of all, noting that the doctrine in the PRC is a doctrine of absolute immunity, and the second question involves the fact that adoption of a divergent position by the Hong Kong courts would prejudice China's sovereignty and hamper its conduct of affairs in the ways I identified. That underlies the conclusion that at paragraph 364 on page 147, that there is no room for the Hong Kong courts to adopt a different policy on state immunity, being a matter which Lord Pannick accepted fell within the sphere of foreign affairs. My Lord, we do say it's instructive. I mean, particularly in the light of what my Lord said earlier today, it may well be that an English lawyer will say it's unarguable that as a matter of international law, the absolute doctrine can apply. And that's indeed the position that the Hong Kong court found itself in. But the PRC government took a different view. And it is entirely possible that the UAE government may take a different view from that which is most likely to be prevalent in this court. And this court then does find itself in exactly the same dilemma as the Hong Kong court found itself in. And the solution is the same. This court must give way to the determination of the policy, including the nature and extent, and indeed questions of waiver as well, which the Hong Kong court looked at. All of those fall to be defined, as it were, by the centre and not by the unfortunately, this court. Can I ask you to flick back in this report to paragraph 75, because the court foreshadowed its analysis with some conclusions, which you find at page 183. And its conclusion was at 183A, the Hong Kong cannot, as a matter of legal and constitutional principle, adhere to a doctrine of state immunity which differs from that adopted by the PRC. Doctrine of state immunity in HKSR, as in the rest of China, is accordingly a doctrine of absolute immunity. And then they went on to consider whether there was any basis for waiver and refer at item 3 to the fact of making a reference. I don't understand my learned friend to demur from the general proposition that is at 183A. But can I ask you then to move back, I'm sorry, in the main analysis in the judgment to page 132. And at paragraph 321, the Hong Kong court notes that it is for states to define the bounds and exceptions to their own practice of state immunity. The one-voice principle and the acceptance of declarations of facts of state as conclusive are rules, whether judicially developed or statutory, are designed to avoid inconsistency between organs of government in defining national foreign policy. The debate tends to centre on which branch of government, usually either the executive or the legislature, ought to be allocated the responsibility for authoritatively determining such policy, with the courts to be left to implement the same. It is unheard of for the courts of a region or municipality, which does not exercise sovereign powers, within a unitary state to declare their own separate policy on state immunity, which differs from that practiced by the state or the nation as a whole. And then, may I ask you to go back to page 99. In the report, where it's noted that much of the argument was which branch of government is to make the decision. Many states place the responsibility on the executive branch, Ministry of Foreign Affairs. Other states may regulate state immunity questions through legislation. In yet others, the courts of law may do it. The approach adopted in any particular state must depend on its own constitutional allocation of powers, and the particular doctrine of state immunity espoused will depend on how it perceives its own foreign policy interests. And my Lord, we do say that this is a very helpful signpost to this court's approach to Article 121.1 of the UAE Constitution. May I then just flick forward to paragraph 241, page 102. Again, highlighted section. If in principle is accepted, as Lord Panic accepts, that it is for the executive branch of government to determine whether a particular claimant is a sovereign state upon whom the forum state should confer immunity, we fail to see why it should not be equally for the executive to determine what exceptions may exist to the grant of immunity. And we say that's extremely important, because if one is talking about waiver, then we say that waiver forms part of that which is to be determined by either the executive or the Supreme Courts, according to the constitutional setup in the particular state. Can I, before I close this case, just take you to page 115 and paragraph 275. Where it is said, nor do we accept the suggestion that the courts are the most appropriate organ of government, and that legal analysis is the most appropriate means for determining a nation's state immunity policy. Each state will allot the responsibility to the executive, legislature, or the courts, as the case may be, in accordance with its own constitutional arrangements. So we pray in aid of the reasoning of the Hong Kong Court of Final Appeal, and we do say it is helpful guidance to this court in its approach to the UAE Constitution. I did say before that I would compare the UAE Constitution with the basic law. My Lord, again, in terms of timing, my Lord can read them both. And both passages that I wish to refer to are quite lengthy. But I would ask my Lord to compare Article 158 of the Basic Law, which you will find in Bundle G1 at tab 20, with Article 151 of the UAE Constitution, which you will find at G1 tab 24. And we say that there is actually a marked similarity. And if under the UAE constitution it is necessary to find, as it were, a legislative unconstitutionality as a threshold of a reference, then we would say that legislation is the DIFC arbitration law and the judicial authority law, in that it is said that they give jurisdiction to the DIFC courts to determine the law of state immunity for the whole of the UAE. And so we would say that it is for the clarification by the Union Supreme Court as to whether or not the DIFC arbitration law and the judicial authority law enable the DIFC to apply a doctrine of state immunity, and what that doctrine should be, both in terms of its effect, whether it's restrictive or absolute, and in terms of its exceptions. The UAE has located responsibility by the Constitution to the Union for foreign affairs. Foreign affairs include the question of state immunity, to whom it's extended, in what circumstances, and the conditions to be satisfied, and its effect. What does the Constitution mean by reserving foreign affairs and therefore state immunity to the Union? Are the courts competent, as the claimants say, to opine upon these matters? Or is it the exclusive province of the executive, as was the case with the PRC? We say these are issues of interpretation of the Constitution, and ultimately, then, it is a matter for the Union Supreme Court to interpret the Constitution so as to bind the whole Union. I have already taken you to the provisions of the Constitution and indeed the Union Supreme Court law on that point. So, my Lord, in summary, what I tried to develop there is the argument that really one is almost inevitably faced with a reference to the Union Supreme Court to determine the nature, extent, and exceptions from the doctrine of immunity which we say would apply. So that brings us to the question, is the KRG entitled to immunity in respect of the claim, assuming good service? We say that we have established that the KRG is a sovereign entity in its own right, or alternatively exercises devolved sovereignty of the Iraqi Republic under the Constitution. We say we've established that the heads of agreement with the claimants were made in a sovereign capacity. And thirdly, that the UAE does have a doctrine of state immunity, albeit we cannot know if it is the absolute or restrictive variety without the guidance either of the executive or the Supreme Court, depending on which the Supreme Court says, under the Constitution, is the appropriate organ of state to make the determination. And so the remaining issue is whether the KRG has waived its immunity. And really, in the time left to me, I'm going to develop my submissions on that. And so I tried to husband my time to allow me to do that in a bit more detail than the bits I've rushed through now. It's probably worth reminding ourselves what was said in the heads of agreement. And to do that, you need to go to bundle E3. At 134. Is that right? No, I'm sorry, that's a bad reference. E1. It's E1. Okay, thank you very much. That's my bad typing. Bundle E1. There are I think probably there are three provisions that I need to take you to. The first one is at page E127, clause 15, where the agreement is to be governed by English law, together with any relevant rules and customs and practices of international law, as well as the principles and practice generally accepted in international petroleum industry. And then the next paragraph, or next clause, is clause 16. I won't read it in its entirety.
No, well, I've read it.
You've read it, my lord.
Yes.
And then, of course, to remind my lord, there is also at page 134, which is where I got the 134 from, at the middle of the page, the central bullet, KRG waives on its own behalf and that of KRG any claim to immunity to itself and its assets. I'm sorry to go back to the Congo case very briefly. Perhaps my lord doesn't need to turn it up if I just read it. For the note, it's at G2, tab 42, and I'm just going to go to page 152 at paragraph 379, because it is a convenient summary of the modern law, or at least the modern common law, on the point. And what's said is this. It is well established at common law that a party seeking to enforce an arbitration award or judgment against a foreign state on the basis of a waiver of state immunity must establish waiver at two distinct stages. The impleaded state must have waived both its jurisdictional immunity from suit in the forum state and the immunity of its property from execution by the forum state's process. And the court then went on to consider various authorities and indeed referred to the fact that it's a matter that's dealt with by legislation in the United Kingdom. And then page 154, paragraph 386, Hong Kong, as the DIFC, doesn't have such legislation. The common law rules therefore apply, and they are very chary about implying any waiver. They require there to be no doubt that a submission to the court's jurisdiction is actually what the impleaded state intends before jurisdiction is assumed. Thus, in Miguel against the Sultan of Johor, and then the Court of Final Appeal quotes Lord Isha there, and the very well-known passage about actually doing it waving in the face of the court. If it is shown he is an independent sovereign, does not submit to the jurisdiction, the court has no jurisdiction over him. It follows from this that there can be no inquiry by the court into his conduct prior to that stage. And it's Lord Justice Lopes who says the only mode in which a sovereign can submit to the jurisdiction is by a submission in the face of the court, as for example by appearance to a writ. And Lord Justice Kay says the foreign sovereign is entitled to immunity from civil proceedings in the courts unless, upon being sued, he actively elects to waive his privilege and submits to the jurisdiction. Then just passing down the page, the Hong Kong court also refers to the decision of Mr. Justice Saville, as he then was, in A Company v. Republic X. On the authorities, no mere inter-parties agreement could bind the state to such a waiver, but only undertaking or consent given to the court itself at the time when the court is asked to exercise jurisdiction over or in respect to the subject matter of the immunities. So, we do submit that the common law is that the waiver of immunity must be given expressly to the court before which the sovereign is impleaded, and that advance agreement will not do. we're not talking here about arbitral tribunals or indeed the courts of the seat of the arbitration. And so we say that, in fact, the judgment of Mr. Justice Burton is not relevant. And consequently, it is wrong to suggest that the KRG is bound before this court by any finding he may have made. This court is not the court of the seat. It is the court before whom the claimants are seeking to have the awards recognised and enforced. The KRG has agreed to the court's jurisdiction. The KRC, in our submission, has to agree to the court's jurisdiction as the common law requires for any waiver to be effective. It is the situation that the common law was changed by the SIA in England, and it's necessary in this connection, and indeed to develop this line of reasoning, and also to answer my learned friend's submissions, to look at the NML Capital case, which you will find in tab 3 of bundle G3, tab 63. So this is a decision of the Supreme Court of 2011. It is, I emphasise, a decision under the SIA. Can I take you, please, to paragraph 126, which is internal page 541. And just to look at this paragraph before I look at the paragraphs above it, what Lord Collins recognised there was that the common law principle in Kayhan v. Pakistan Federation was reversed by the 1978 Act. So it is clear that the 1978 Act reversed part of the common law. And we are looking at the common law before the changes in the Act. And so the post-Act authorities upon which my learned friends rely are not helpful to this court. Nevertheless, reliance is placed upon this decision to attack the principles that I just extracted in summary from the Hong Kong Court of Final Appeals judgment on where the common law stands. And it is, my learned friend relies upon the passages here. I wonder again, in the interest of time, and my Lord may have read them, but could I invite my Lord to read to himself before I make the submission, paragraphs 121 to 125 inclusive. Yes.
With 121 to 125, yes.
I'm grateful, my Lord. May I therefore make the following submissions? As I said before, this is a case which is not decided under the common law, but under the SIA. And Lord Collins affirms in it that before the SIA, he uses the expression, it was thought nothing less than appearance for the court would do. He says was thought because, as we see at paragraph 125, he cites the article of Dr. Mann, which is critical of that line of reasoning, and because that article suggests that the cases following Miguel might not be good law. But the critical point is that Lord Collins does not suggest that Miguel itself is not good law. And so we do say that whether or not the cases following it are or are not good law, it goes nothing to the point. The point is that the Hong Kong Court of Final Appeal was correct in following Miguel, and Miguel does represent the common law on the point, namely that if a party, a sovereign party, is to waive immunity, it must do so effectively in the face of the court. The claimants refer to the Republic of X case, the decision of Mr. Justice Saville, and indeed he found essentially the same point, as again was cited by the Hong Kong Court of Final Appeal, and we suggest that that case does not assist the claimants in any way. In fact, the case is mostly about whether or not under Article 13, under Section 13.1 of the SIA, there had been consent to allow the making of a freezing injunction. And indeed that was followed in the Sabre Shipyard case, to which the claimants also make reference. That case does not concern the common law at all. But reverting, if I may, to my theme, to a large extent this debate, which is quite granular on the issues of English common law, could become purely academic. What was the common law before the SIA will be of no interest to the UAE. As the Hong Kong Court of Appeal, Final Appeal recognised, immunity is an essential part of the doctrine to be determined by the competent organ of the state. It is, however, we would suggest, possible that the UAE may be more influenced by the UN Convention than English common law as it existed in 1997. And we'd just like to draw this court's attention to Article 7 of the UN Convention, which is to be found in Bundle G1 at tab 32. It's internal page 7. Article 7, express consent to exercise of jurisdiction. A state cannot invoke immunity from jurisdiction in a proceeding before a court of another state with regard to a matter or case if it has expressly consented to the exercise of jurisdiction by the court with regard to the matter or case. A, by international agreement, B, in a written contract, or C, by a declaration before the court, or by written communication in specific proceeding. In the present case, the KRG has not expressly consented to the exercise of this court's jurisdiction with regard to this case. The claimants may make such comments as they like on the convention, but frankly, we are all somewhat in the dark. The UAE may choose to adopt an absolute doctrine of immunity, or it may choose to follow or be inspired by the wording of the UN Convention. The UAE may consider that it is not possible to waive immunity at all. I would like now to go back to Lady Fox's book on this subject, which you will find in bundle G3 at tab 85. And she comments on this aspect of the UN Convention at internal page 382 under the heading Consent under the UN Convention. And she cites the International Law Commission's commentary. I'd just, if I may, like to look at the final 3 lines of that. Consent by the state involved in a litigation are not absolutely binding on a court of another state, which is free to continue to refrain from exercising jurisdiction.
I'm so sorry, I'm looking at 382.
Yes, internal page 382. In the middle of the page, there should be a heading, Consent under the UN Convention. I'm reading under the ILC commentary. Perhaps I should read the whole thing.
Yes, thank you.
The exercise of jurisdiction, or the decision to exercise or not to exercise jurisdiction, is exclusively within the province and function of the trial court. In other words, the rules regarding the expression of consent by the state involved in a litigation are not absolutely binding on the court of another state, which is free to continue to refrain from exercising jurisdiction, subject, of course, to any rules deriving from the internal law of the state concerned. So it is entirely possible for the UAE to say that we say you can't waive your immunity. It is very much a matter for the policy of the jurisdiction within which the sovereign is impleaded. She goes on to say that in practice it would seem that to be effective, an express waiver must identify the court proceeding matter or case, and this requirement will prevent any expression of consent in an international convention constituting a waiver. She then goes on the next page to consider international agreements. And again cites the International Law Commission supporting a view that undertaking in a conventional contract without specificity as to the dispute and the court will be insufficient to constitute a waiver. And she cites in extenso from the ILC. At page 384, I'd just like to take you to the final part of that citation. Last 4 lines. Customary international law or international usage recognises the exercisability of jurisdiction by the court against another state, which has expressed its consent in no uncertain terms. But actual exercise of such jurisdiction is exclusively within the discretion or the power of the court, which could require a more rigid rule for the expression of consent. I draw this court's attention to that merely to illustrate that, as I said before, we are somewhat in the dark as to what the policy may be decided to be for the UAE. So in summary, we submit that the KRG has not waived its right to assert sovereign immunity before this court as a matter of common law. Nowhere has it been suggested that Miguel is not good law, and it has been followed in Hong Kong, nor has it done so for the purposes of international law as expressed in the UN Convention. So far as the position under UAE law is concerned, no one at the moment can assist. The net result is that this court cannot hold that the KRG has waived immunity, and we say it is bound to refer the point to the USC. Finally, therefore, we come to a short submission that we make in our skeleton, where we submit that when a state acts de jure imperii, the New York Convention does not apply, whereas the arbitration agreement unless the arbitration agreement specifically contains a provision stating that the New York Convention applies. And we rely upon an academic writing to that.
I'm not quite sure where I see where this point goes, Mr. Black.
Where that goes, my lord, is this, that it's an additional reason. We say, if it is right, and I have to accept it is a bold submission and a bold statement in the textbook, but if it is right that the New York Convention does not apply to a decision in relation to a state acting in a sovereign capacity, then it would follow that there would be no grounds upon which we say this court could enforce that award. We say that in this, my lord, it's probably another way of expressing sovereign immunity, albeit in a rather roundabout way, frankly. And it's not a point I labour. It comes from some Swiss writings, and my lord, I've looked at the underlying articles, at least in English, and it does appear to be ex cathedra rather than without any underlying analysis. So, my lord, I leave that there.
It's in your skeleton.
It's in my skeleton. My lord, can I just finish really with the question of material non-disclosure?
Yes.
And just to summarise where we stand on that. And we do rely upon two matters of material non-disclosure for the reasons that I prefaced before. One, in relation to the first order itself, it was incumbent upon the claimants on a without notice application to inform the court of all the legal issues. They should have informed this court that the KRG could, and indeed probably would, argue state immunity applies in the DISC. And secondly, on the application for substituted service, they should have informed the court of what now appears at paragraph 125 of their own skeleton, namely that where the terms of a convention apply and are mandatory, the court may order alternative service in exceptional circumstances. No exceptional circumstances were identified, only the question of delay. So even on their own case, as now presented in the inter-parties hearing, they did not inform this court as to the proper basis upon which the Riyadh Convention could be disregarded. And they did not, as I say, inform this court that it is the correct analysis, both of the Riyadh Convention and the rules of this court, that service cannot be affected by a manner which is contrary to the law of the place of service, which is Iraq. And they did not establish that substituted service is permissible under the law of Iraq. The upshot of all of that is that the order for substitute service must be set aside in our submission. And if that is right, everything else falls away with it. Unless I can assist my Lord further, those are my submissions.
Forgive me for being slightly slow on this, but the effect of your submission that the matter should be referred to the Supreme Court, the only decision they could then give is as to which organ of state then decides on the question of the width.
My Lord, that does appear, if one, on analysis of the Hong Kong case, and unless we are able to make a definitive submission to my Lord that Article 1211 imports a duty in the court itself, then the first question for the court is whether the court, USC, as an interpretation of the Constitution, is the appropriate organ of state to determine the issue, or whether it should be referred to the Ministry of Foreign Affairs of the UAE.
I mean, it could decide for itself.
It could.
That it's in the same position as the British court seems to be.
Yes.
And therefore it would interpret international law
Yes.
in a manner consonant with
Yes.
its own law and decide what the width of sovereign immunity was.
Yes.
Alternatively, it could say, well, this is a matter for the legislature,
Yes.
and we can't make any decision at all.
Yes. And what goes before the court, it's something that perhaps can be discussed further if my lord is minded to accept our submission on this. What goes before the court is a reasoned judgment of this court asking for the guidance, and it may be that is the appropriate point at which the parties make submissions as to precisely the question that should be put before the Union Supreme Court. And indeed, as I understand it, it is perfectly open for this court to express its own views.
That wouldn't be possible on your...
No, it is perfectly possible for this court to make a tentative view and ask the Supreme Court whether or not those are correct. As I understand the provisions which call for a reasoned judgment of the court is to give its reasons as to why it feels it would be assisted by a decision of the Union Supreme Court. So no doubt, whatever view the court took, it may say this is our view, and we would be grateful to know whether this is correct or not.
Yes.
Unless I can help further.
Not at this stage. Thank you very
Thank
much.
you.
Thank you. Yes.
Your Honour, as my learned friend mentioned at the outset, my skeleton argument takes things in a slightly different order. And the reason for that really is that as we see it, the issue of state immunity really runs through everything that my learned friend says. It's not the only point he's got on service. So he has his point on the Riyadh Convention generally, and I'll deal with that. But this sovereign immunity point is raised, for example, in his other service complaints. So we heard this morning on the issue of service an awful lot about the sovereignty of his client, the sovereign status of the KRG. And in fact, its status as a state was said to be both orally and in the skeleton as being the threshold question. Now, he also said, well, you can't get started until you establish service because jurisdiction depends on service. Well, firstly, it doesn't. It doesn't in this court, at least. This court of statutory jurisdiction. That's why we don't have rules for permission for service out. If the court has jurisdiction, it has jurisdiction. How do you find that out? One looks at Article 5A of the Judicial Authority Law and the laws associated with that. But I'll come on to that. But in developing his position on that, my learned friend took your lordship to a Canadian case about the need for service to establish against the state to bring a claim to enforce an arbitration award. But again, interweaved into that was the position of the defendant in that case as a state. So my point, for my part, it seemed to me that it would be more helpful just to grass the nettle and deal with the question of state immunity first. I'll deal with all the issues, but if I could deal with that first and then go on to questions of jurisdiction and service, that I would hope would be helpful. It also rather matches the way in which my friend's submissions have developed. He started with state immunity, went to service, and then came back to state immunity, position status of his clients.
Well, as I said to Mr. Black, if the position is that he's wrong about waiver,
yes,
then I don't need to go into the difficult areas that he suggests ought to go off to the Supreme Court of the UAE.
Yes.
And that would help me if you were to deal with waiver early on.
And
in truth, his case depends entirely on Mikhail being good law.
Yes.
That's the reality of it.
That's the reality of it, and it isn't.
At least as I see it. And that's the area that I'd like to deal with, basically the arguments that you're putting in the last 20
That's what I was proposing. That's what I was proposing to deal with first. I was going to take this issue of whether there's a law of state immunity at all in the UAE.
You take whichever.
But it's quite a short point,
I'm
and then I'll go straight to the waiver.
Simply telling you what I'm most interested in.
I understand. I'm grateful. Then I'll deal with the Union Supreme Court point, if I may. Just to wrap that up.
You take it whatever order you want, Mr. Montague-Swift. I don't want to divert anybody from the course of their argument. I'm just indicating the areas that I presently see as likely to be decisive.
I'm grateful. I'll be quite brief then, if I may, just on the question of whether there is a state immunity problem at all. But as Your Honour says, the waiver point rather cuts through that, if Your Honour's with me. So my position, my own friend's position is that this court should apply what he describes as the common law of state immunity. And the reason for that, as I understood his submissions, is that the way in which English law incorporates or deals with state immunity is to incorporate recognised standards of international law, if I can put it like that. Mm-hmm. And so the logic, as I see it, is the same here. But my learned friend presents something of a moving target, because we've got this appeal to the common law of state immunity and therefore recognised standards of international law. And sometimes that's equated with the United Nations Convention on immunity of states and their property. But sometimes, Your Honour will have picked up on this, my learned friend selects the specific approach of English law and the English courts at a particular point in their development to specific issues, and the waiver point is precisely one of those. Just to look at it broadly, one can generally say that most states apply the restrictive doctrine of state immunity, firstly, and secondly, that a state can waive immunity. But there isn't a lot of consensus about the detail of how those broad principles are applied. And we see that in the case of Trentex, which Your Honour was directed to. We won't go back to it, but that's precisely what Lord Denning says. He says it's a bit of a myth to say that there is this corpus of this body of international law, because everybody applies them in different ways. And so not every state implements what's understood even to be the basic principles of public international law. And the example of that is the case of the Germany and Italy case. And that was, again, Your Honour can take into it, but that was a case in the International Court of Justice, and arising out of the Second World War. And the result in that case, the finding of the International Court in that case, was that Italy's laws breached the general principles of public international law. And the result was that Italy was directed by the courts to do something about it, to change its laws. So international law is relevant, but fundamentally the question of how it applies in any particular state is a question of domestic law. How does domestic law bring those principles into play, if at all? So where do we find the principles of state immunity that are at play here? And it seems to me that what we've got to do is we've got to start with the position of the UAE generally, and then ask, could it be right that the DIFC would have a different position? My learned friend is absolutely right that we're both ad idem on that. That, as I put it in my skeleton, the law on this point here must match the law in the UAE. Both parties accept that for slightly different reasons, but it doesn't really matter what those reasons are. They're quite complicated reasons, potentially. So if we start with the UAE law, I say UAE law just doesn't recognise a general doctrine of sovereign immunity at all. There are specific instruments that confer immunities. You have the Vienna Convention, which confers diplomatic immunities. But outside of that, there is no general principle. My learned friend says, well, that is just absurd. And to parrot some of the words that he used in his submissions, tell that to the Dubai Court of Cassation. Because my learned friend took Your Honour to various authorities, but he didn't take Your Honour to the key authority on which I rely, which is the Dubai Court of Cassation decision from June 2013. We find that in the first authorities bundle at tab 10. Your Honour has that. That's a decision in a case between the Central Bank of Sudan and the company Africa Alpha Capital. And what had happened is that Africa Alpha Capital had taken assignment of a loan debt and was seeking to pursue that debt against the Central Bank of Sudan. If we go forward to page 5, you see, if you want to just read halfway down the page on page 5, the appeal is based on 3 grounds.
How far do you want to read?
Until the end of the next page.
Thank you. Do sit down if you want.
Thank you.
Yeah.
So that case rather cuts across quite a lot of my learned friend's submissions. Firstly, you've got, that's why I said in the skeleton argument, the courts do decide these issues. They don't set the policy, but they do apply it. And the policy is that there is an obligation to act both positively and negatively within the court's jurisdiction, except as provided, except as exempted by instruments. And the Vienna Convention is the one that's relevant. There's also reference to the Riyadh Convention there. That, Your Honour, was taken to it, but it provides an express exemption from needing to enforce the judgments of one of the other states. So it only applies when one's dealing with mutual enforcement of judgments between the member states of the Riyadh Convention.
Can we just have a look at that?
Yes, of course. It's behind tab 28. It's Article 25C. I'll work from my learned friend's translation unless there's a material point.
Thank you.
So 25C is on page 8. So starting with A, in the application of this part of the judgment shall mean any decision, or whatsoever its description, issued in accordance with legal or venue procedures by the court of any competent authority of one of the contracting parties. So this is all to do with mutual enforcement between the contracting states. That's the first point. And then we see the duty to enforce each other's judgments. I won't read that unless Your Honour's interested in it. And then C, this is the exemption that's being referred to. This article shall not apply to judgments issued against the government of the contracting party which is required to recognise or execute such judgments, or against one of its employees. So the point there being contracting states are not, by this article, required to enforce judgments against themselves.
Yeah.
So my learned friend said in his oral submissions that actually itself confers an immunity. or I may have misunderstood that submission. There's nothing in his skeleton argument to that effect, but it clearly doesn't for various reasons. So unless there is some immunity of that sort, then Dubai Court of Cassation says you have to exercise jurisdiction. And that is the received view, I would suggest, in this jurisdiction and in the UAE, or at least in Dubai. It doesn't come as a bolt out of the blue. My own friend took your on to the various commentary, and I accept that they are assertions, and it may go to questions of material non-disclosure rather than anything else. But this is not a case which has seismic repercussions in the legal community. This is a case which just simply states the position as it's understood to be. And my learned friend, in the face of that, refers Your Honour to effectively two sources. One is this article from, I think it's Professor Turkey, and the other is Egyptian law. Just dealing with them in turn, I think we do need to go back to Professor Turkey's article, writings. We find it in bundle 3, tab 73. So we have to go back because we've got to read on from where my learned friend stopped. Tab 73. My learned friend took you on to page 2, or it's the second page, page 317. And so, at the top, this is the passage that Your Honour was referred to, the lawsuits filed against persons enjoying judicial immunity, and then refers to the international law rules. It says grant a judicial immunity to the international legal personalities. And I want to ask Your Honour to reread that. But if we go to the next passage, it says, in the past, the judicial immunity was applied on the actions made by those persons, whether regarding to their position, or if it is not included within the scope of their positions, for example, it may be related to their personal life or a professional or commercial activity conducted by them. But that immunity became only inclusive of the tasks performed by them within the scope of their official capacity pursuant to the provisions of the Vienna Convention on Diplomatic Relations in 1961, to which the UAE became a party under the Federal Law No. 4 of 1971. So we see that, firstly, what he's describing in the prior passage is about diplomatic immunities. And then there is a change when the Vienna Convention is ratified, in that the immunities conferred on the individuals become narrower within the terms of within the confines of the Vienna Convention. So it doesn't appear to my reading of this that he's asserting that there is any wider general law of state immunity outside the scope of what is said in the Dubai Court of Cassation case, in the Bank of Sudan case. And if he was going beyond that, he was wrong. And Your Honour will note from the first page of this that he wrote this in 2009, which was 4 years before the Bank of Sudan case was decided.
I'm somewhat unclear as to what it is he is dealing with. He starts off by talking about international legal personalities, including states, organisations,
yes,
and international bodies.
So you're right, it's confused, because he does then continue to say in the past judicial immunity was applied on the actions made by those persons, whether regarding to their position, but that has been confined by the terms of the Vienna Convention. So there are two answers. One is that he's simply confused.
At footnote 1, he refers to the presidents of the states.
Yes.
So this isn't Vienna Convention diplomatic immunity, is it?
That may be right.
Appears to be talking about a general principle of comity.
That may be right.
One president doesn't have a go at another president.
Yes. So there's in there traces of what one might see as being a broader view of a general rule of immunity, but he conflates that with the sorts of immunity provided by the Vienna Convention, and then he says, but they become narrower.
Is there any help to be gained from the rest of the article?
I hadn't proposed to take your honour to it. But I don't believe that there's an awful lot of clarity there. It deals with the convention.
Seems to be thereafter about diplomatic envoys.
Yeah. Deals with the convention.
Yeah. All right.
So, as I say, either he's simply confusing and conflating diplomatic immunities with the general sovereign immunity, or he's asserting that there is a wider sovereign immunity, but he's wrong, and we know he's wrong because of the Dubai Court of Cassation case. The second approach is then to rely on Egyptian authority generally, and there's no doubt from the authorities that my own friend has produced that the Egyptian courts do recognise the principle of restrictive immunity, and they're one of many courts around the world that do that, and it's right that some of those courts are civil courts. So I'm not suggesting that there's a general rule that no civil court can have judge-made law in this area. Well, that's not what I'm suggesting. But I'm saying that that in this case we'll concede from the Dubai Court of Cassation decision that's not the position. But the other point, though, is that there's just simply no support whatsoever for relying on Egyptian law in this context. My learned friend says, oh, well, we generally do that in the UAE. And on advice from co-counsel, he says, well, that they're likely to follow the Egyptian precedents. Well, my co-counsel say quite the opposite, but that's not the point. The point is that if that were the case, there would be a source that could be relied on. Now, in some cases, legislation in this country does derive from Egypt. So the Civil Code, for example, has some of its history in Egypt. And in that context, obviously, one looks not just necessarily to Egyptian law, but perhaps even to French law on those issues. But there's simply no comparison in a situation like this, where my own friend says, well, actually, this is so central to the federal state's position that even the courts can't decide on this. Why on earth would we be looking to the position taken by the Egyptian courts on that? And we see also, again, back in the Bank of Sudan case, there's no reference there to Egyptian authority. And so the short point is then there just isn't a general, and it may be startling to some, and the result may or may not be perceived by others as a breach of international law. But that's not the issue for today. So once we get to that position, the next question is, well, can the position be different in the DIFC? And as I've said, both parties say no. And we said for slightly different reasons. But my main focus, and this was where my arguments were described as a straw man, because I was relying on the law on the application of civil and commercial laws. The reason I produced those is because that is the well-trodden path through which parties always try to introduce principles of English law or other systems of law which they want to try and say apply in this court. And that doesn't work for a whole range of reasons. And my own friend says he doesn't rely on it. But then he does take Your Honour through various cases which he says show that Your Honour is entitled simply to import, quotes, the common law. Can I just go back to some of those very briefly, if that troubles you? I can do it two ways. I can just give you one of the references and say what I say about them, or I can take you on to those cases. Given that both parties agree position has to be the same in each, but both outside the DIFC and inside the DIFC. It may be that there's not an awful lot of point in labouring.
Well, if the Court of Cassation case is determinative, it's determinative. It's as simple as that, isn't it?
Yes.
And your submission is that it is.
Yes. Yes. The next question then is simply, it's determinative, certainly determinative outside the DIFC. Can it somehow be different inside the DIFC? And if both parties agree that it can't, then that's the end of that.
Well, as I understand Mr. Black's argument, that will take precedence in any event.
Yes, that's cool. So we had a lot of arguments about how this court can import common law principles. Your Honour was taken through the Court of Appeal decision for Del Felicia, which is all about expert evidence on foreign law. And in that, he cites actually the Court of Appeal reciting some of my submissions, not all of which I think were accepted, but it's hard to see how that has any impact on the outcome of this case, any of it. I mean, I disagree fundamentally with quite a lot of what was said, but it's hard to see how it has any impact once my learned friend accepts that if there's no principle in the UAE of general sovereign immunity, then you can't import one into the DIFC. And that must be his submission, because he says it has to be the same.
Well, and it says it has to start with the UAE,
And it has to start with
not with the DIFC, which is only a part of it.
Or the Court of Cassation of Dubai, which is only a part of it. So that submission is difficult as well, in light of that Cassation decision. But, Your Honour, just simply to
I'll just take you through those.
I'll take you through those cases.
He relied on.
Certainly. If we go then first, please, to Fidel and Felicia, that's Bundle 1, Tab 12. And the particular passages he relied on were subparagraph 9G.
I'm so sorry, I'm lagging behind a little. Where are we going now?
Bundle Authorities 1, Tab 12.
Thank you.
This is the first authority
Yes.
relied on 3, I think. And it was page 9, I'm sorry.
Yeah.
And then subparagraph little g. These are the respondents' arguments, so you can see that from top of paragraph 13.
That was you, was it?
That was me, I'm afraid, yes. Yes. And G, it says, if expert evidence of non-DIFC UA law were required in every case, because it is a foreign or non-DIFC law, then expert evidence would, a fortiori, be required of all other foreign laws, including English law, which would be an absurd result. So my position was, you can't have expert evidence in every case, because then I'd have to produce an expert report in front of Your Honour, which would be absurd. The appellant attempted to avoid this conclusion by stating that the DIFC law incorporates common law, but DIFC law is not solely the law of England and Wales or of any other common law jurisdiction and differs from orthodox common law in several respects, including on matters as fundamental as contractual interpretation. And my point there was that the law of the DIFC on contract is codified. It's codified in the contract law. So whereas in English law, we look to the cases to determine what, say, the constituent elements of a contract are and how does one go about interpreting a contract. But in the DIFC, we don't do that at all. We look at the contract law. And the contract law says actually something different from the English common law. So the point about saying that DIFC law is not solely the law of England and Wales and incorporates other common law jurisdictions is to say that the sources of the legislation are all over the place. So the difference on this particular point is that when one's construing a contract in the DIFC, one is required to look at the behaviour of the parties after the contract's concluded, which of course is totally contrary to the way that we do it in England. So there's absolutely no support there whatsoever, even for a submission by me, that one can import the common law. Then if we go forward to page 13, you see paragraph 55. This is the other paragraph that was referred to. It's immediately apparent from its origins that the fact doctrine does not readily apply to DIFC. Unlike the English courts, DIFC courts are not restricted to applying English common law or even DIFC law, And that's where my learned friend stopped, and I asked him to read on, because it says, with regards to substantive law, the DIFC courts are, pursuant to 8.2 of the DIFC, that's the law in the Act, that's Article 8, that's my Article 8
Yes.
point, allowed to apply laws other than the DIFC law, including the laws of any jurisdiction expressly chosen, the law of the jurisdiction agreed, the law of any jurisdiction which appears, and so on. So they're reciting the terms of that. And then, this was the point, really, the determinative point. With regard to rules of evidence, the DIFC court may, pursuant to Article 50C of the DIFC court law, apply rules it considers appropriate. So they're rejecting the introduction of common law, the insertion of common law into this procedural issue of whether or not you need expert evidence. And when the court said, well, you can bring common law in, they expressly refer to Article 8. As your Lordship saw that, it's an attempt, in effect, to be a conflicts of laws provision.
Yes.
It's slightly dysfunctional, I suggest. Now, there's been a series of cases, and I won't go through them, but a series of cases in which parties have tried to import some or other aspect of English law. Because for a long time, people would say, repeatedly, that the law of the DIFC defaults to English law by reference to Article 8. But it just doesn't. And so there's been a series of cases, I refer to them in my skeleton argument. For example, in the question of priorities on insolvency, the question was, does the DIFC law import the English law of priorities, or indeed the UA law of priorities on insolvency? The answer was no, it doesn't do anything. On the law of unfair dismissal, the question was, well, is English law imported there? The answer was no. So John Chadwick was asked to look at the question of whether the English law of contractual penalties should somehow be imported. And he said he didn't have to decide the question, but he thought his provisional view was no. So there's a whole series of cases where this has been attempted, in fact, and I've referred to them in the skeleton argument, and I won't take you through them given where we are.
I'm just going to ask you to go to that the cascade provision just the same for my own education.
Yes, it's behind tab 3.
It's tab 3, thank you. That's what I was looking for.
It should be it's page 2 at the bottom. So, the difficulty of this clause, of this provision, is that what it says is, since by virtue of Article 3, that's the DIFC law is able to apply in the DIFC, notwithstanding any federal law and similar commercial matters. The rights and liabilities between persons in any civil or commercial matter are to be determined according to the laws of the time being in force in the jurisdiction chosen, in accordance with paragraph 2. And the difficulty here is that it says the relevant jurisdiction is to be the one first ascertained on the following paragraphs, paragraph 1, so far as there is any regulatory content of the DIFC law or any other law in force in the DIFC. So it's really about filling gaps in the law. And it's substantive as well. That was the other effect of protivity. That's why I say it's dysfunctional and hasn't actually maybe successfully applied. But as I say, this is all about whether or not one can import the common law, the state immunity, when I don't think anyone can. Both parties are saying that this court can't have a different.
But tell me, as a matter of statutory interpretation of your submission, the words, the relevant jurisdictions to be the one first ascertained under the following paragraphs, does that mean that only one of those bodies of law can apply, and you take them in the order as they appear? It's not a filling the gaps point at all.
Well, the reason I say it's a filling the gaps point is that it says, subparagraph 2, the relevant jurisdiction is to be the one first ascertained, and then one of the ones, the first one, is any law includes any other law in force in the DIFC.
Oh, I see.
So if there is a law in force in the DIFC, then there's no scope to go down to the next stage.
That's what I mean, but it's a hierarchy.
Yes, correct, yes.
What I was putting to you.
Yes. So say there was a question about defamation, then arguably one might say, well, there's no legislation on defamation.
Yes.
I suppose, and then one might go down to the laws of England and Wales. One might. But I mean that itself is problematic because one's talking about a tort which in England is a civil tort, but which outside of the bounds of the DIFC is also a crime. So that's fraught with difficulty in itself. But the reality is that this is, as far as I'm aware, has never been actually applied.
But looking at this more generally,
Yes.
we have a limited body of statute law.
Yes.
In the DIFC. I've forgotten how many statutes it is, but it's a comparatively small number. One of the great joys and delights of coming here is it's a relatively small number. But the question is, in the absence of quite applicable law in
Yes.
that form, what then happens? Now, what Mr. Black is submitting to me is this is a common law court, and the court will therefore develop its own jurisprudence in the light of what goes on elsewhere in the world, particularly other common law courts.
Well, as I understand his submission is you can't do that. But one needs a hook in which to introduce that. One needs a legislative provision which permits it, because this is the statutory court.
Well, that's what I was asking.
Yeah.
My understanding of what he was submitting to me was that that's exactly what I should do. I should be applying common law.
Yes.
Because it's a common law court.
Yes.
But not and you fill in the gaps, so to speak.
But not pursuant to this provision.
Absolutely. Not pursuant to this provision.
No.
But my question then is, how does this interrelate with that submission?
Well, it doesn't help him because he doesn't rely on it. And the reason I brought it up at all is simply to show you the limited nature of the application, that there is a provision of that sort there, which doesn't permit what he's trying to do and on which he doesn't rely. So it is a red herring for all of us, because for two reasons. Firstly, he doesn't rely on it, and secondly, because he says, well, it's got to be the same here as it is out there. This court can't develop it.
To go back to your defamation example.
Yes.
Let's forget the fact that
Yes.
it could be a criminal offence elsewhere, and so on and so forth. Do you say, or do you reject the suggestion that the DIFC court will have regard to the common law position in jurisdictions around the world as to the existence of a tort of defamation?
Well, the argument would have to be, on a substantive law position as that, the argument would have to be that you get there by applying, ultimately, that cascade provision and applying the laws of England and Wales.
Well, that's what I thought you'd say.
Yeah. So you don't get to the common law. Now, of course, when one looks at the laws of England and Wales, in interpreting what they are, one might have regard to other jurisdictions just as perhaps the laws of the Supreme
But you
Court
apply
did.
statute law as applied in England and Wales.
Yes.
So that's where you're looking at substantive law.
The reason my learned friend can't rely on us is that if one applies
He
the
takes
substantive,
into the State Immunity Act, yes.
Yeah.
And then he is stuck.
and then he is stuck.
Mr. Justice.
I say he's stuck anyway.
He's stuck, Mr. Justice Burton,
Yes.
whether he likes it or not.
Yes.
Is that absolutely on point, right or wrong?
Yes.
Its issue is stopping.
Yes. That's correct.
Yes, all right.
So,
I'm sorry I'm lagging behind you a little on this.
not at all, but it is to some extent a red herring, because as I say, it moves a long way away from really where the battleground is.
Yes.
Because I say that really the question starts and ends with the divide court cassation decision, and that's that.
Okay, we've dealt, I think, with Fidel and Venecia. We've dealt with where are you going next?
Did you want me to take you on to look at all the other cases that my own friend dealt with?
Remind me what they were.
So there was the Nativity case, which was the case about foreign non-comedians. Activity case was about determining in part, which forum non-convenience principle should be applied. Because in an earlier case, which my own friend knows well, a case called Corinth, this court had decided that it has jurisdiction over any disputes to which a company which has a branch in the DIFC is party. Because a company, say Barclays, the case there was to do with Barclays Bank and a branch which was outside the DIFC. Barclays Bank had a branch in the DIFC, but the dispute related to the branch outside the DIFC. And the Court of Appeal said, well, if it's got a branch, it counts as a licensed establishment, and so then we've got jurisdiction over it. And then to counter the argument that this was an exorbitant jurisdiction, the Court of Appeal said, yes, but we've got authority to refuse to exercise our jurisdiction, and we're going to have to use that authority, because otherwise this would be an exorbitant jurisdiction, and therefore forum non-convenience applies in one way or another. So then activity was really just about understanding where the margins of that were. Yeah. So it's quite different from importing a whole other principle of state immunity, which, as I say, doesn't exist outside the DIFC. If it does exist outside the DIFC, I accept that as a matter of public policy or in some other way, Your Honour can't make an order against the party who is immune. And that brings us then on to the questions of waiver and so on. The other case then that was referred to was the case of Barclays Bank, which was Barclays Bank and an SR.
Yes. And
that was the case which simply dealt with the enforcement of a New York judgment against a party who didn't have a presence here. And again, in an earlier case, the DMB Bank case, this court had decided, well, this court has jurisdiction to enforce judgments regardless of where the defendants exist. Just like arbitration awards, we have a freestanding jurisdiction to enforce a judgment.
Yes.
And Barclays Bank was an example of that enforcement. And it was in that case then simply that Sir Richard Field, Justice Sir Richard Field, said, well, we just apply the common law rule. Now, the hook for that was that there is a statutory provision in the court law which says you can enforce foreign judgments. So again, the question was simply, how does this court go about doing it? Does it do it in a, quote, civil law way, or does it adopt the common law approach? And again, so without that legislative hook, you can't simply invent the enforcement of judgments. So if there was no provision which says the DIFC court can enforce judgments, then this court couldn't say, well, under the common law, a foreign judgment of competent jurisdiction, of a court of competent jurisdiction, creates an obligation, and we're going to enforce that obligation. It required a statutory underpinning. And then, because we are a court that goes about dispute resolution in a common law way, the court can select to take the common law approach.
Yes.
Now, my own friend referred to the case of Hemisphere, and he took Your Honour through some of the paragraphs of that. We'll have to go back to some of it. That's the Democratic Republic of Congo case. And that was an example of a case, he says, in which the court said that a special administrative zone, as it was in Hong Kong, that the DIFC could not claim or confer immunity on a basis different from that adhered to by the state. That was the conclusion of the court, and the reference to that is behind tab 42, but it's at paragraphs 267 and 268 of that case. There's a degree of assistance one can get by analogy from that, but it's not a directly applicable case, because there's a lot going on behind that decision in terms of the basic law. So whatever the analysis, as I say, both parties accept that the rules in the DIFC and the UA must match. So, as I say, that's really the end of the point. But my learned friend then says, well, this court can't hear the claim. Why not? Because it's all a matter for the Union Supreme Court. And he says that follows in part from the Hong Kong decision that I've just mentioned. But the question in Hong Kong, and this is what was rather overridden when my friend took you to that case, the question in Hong Kong which was referred was the question of whether or not the Hong Kong court could depart from the policy that was laid down by the government. It was not the question of what is the policy of the government. And that could have been the subject of a certificate from the Hong Kong court. They could have sent off for a certificate from the government. And we see that as paragraph 356 of that case, but I won't go back to it.
I saw that.
And in that case, the court expressly said that it could decide the case, even if it couldn't decide the policy. So there's a distinction. It's not saying, it was never saying we can't actually look at a plea of state immunity. It says expressly it can decide the case. That's paragraph 344 on page 140 of the decision. And the court did go on to consider the question of whether there had been a waiver. And it decided that question. Decided it by a majority of 3-2 against there having been a waiver, applying this Miguel line of authority. And my learned friend says, well, the Hong Kong decision shows that the question of what's accepted from state immunity is a matter for central government. And that includes question of waiver. But that's just not what that decision said. It says the exception is whether or not there's an exception for commercial activities. But it can and did go on to consider the question of waiver and treated it as a universal principle of state immunity. We see that on pages 151 and following of that decision, and they decide the issue at paragraph 393. And as I say, what was referred was the question of whether the Hong Kong Special Administrative Region could go it alone, in effect, on state immunity, could depart from the general policy. And we see that at paragraphs 406 and 407. And the crucial point there was that there was a specific power and duty to refer those issues. But all of these submissions that this court can't go it alone, that it's not for the courts, at least of this court, to decide the policy issue of what's covered by sovereign immunity. All of that makes a powerful argument, I would suggest, against judge-made law in this area. Because if it's right that the policy on this has to be laid down by the federal government, then there is just no room for the development of the doctrine of sovereign immunity. It needs to be implemented by the federal government, by treaty. You can do that in a number of different ways. The moment the position is one has specific individual treaties like the Vienna Convention, like the Riyadh Convention, which give certain specific immunities, the solution in the future could be to sign up to the United Nations Convention on state immunity. They haven't done so to date. But absent that, just like the Court of Cassation in Dubai, this court has to exercise its jurisdiction and has to apply the legislation which allows it to do that. And the legislation here, Your Honour, has been taken to all of it, is simply Article 5A1E of the Judicial Authority Law. That gives Your Honour exclusive jurisdiction over claims, civil and commercial claims, which arise out of, well, in respect of which this court is given jurisdiction by DIFC law. And then Your Honour is given jurisdiction by Article 42 of the Arbitration Law, which requires this court to enforce the award. There's no discretion to refuse, just like on the usual terms of implementing legislation for the New York Convention. There's no discretion to refuse unless one of the defences arises. And that is the end of it. There is this defence of public policy. That, I say, is where one would find questions of sovereign immunity if they arose. But one has to find them in the UAE public policy, and that's how the principle is imported into a case like this. And the Court of Appeal has grappled to some extent with the question of whether or not principles of foreign non-convenience could apply in relation to a claim to enforce an arbitration award. That was the Banyan case. And they take the same position as the English courts. It doesn't work, because the only court that could enforce is this court, and there's anyway an obligation to enforce if the conditions are met. So that's all I wanted to say about the question of whether or not there is this overarching principle of state immunity in this court. There's none outside of the court, and there's no way to import it in. So my own friend says it's absurd. Well, not obviously. In fact, it's pretty clear, I would suggest, from cassation authority that this just doesn't get off the ground, and that is why, in the application, Mr. Benson's witness statement said there's no law of sovereign immunity, in general law of sovereign immunity in the UAE. That was a correct statement. Now, if I'm wrong about that, we move on to the next stage, applying whatever it is, the common law of state immunity. And again, I say that we've got a bit of a moving target here, because one has to bear in mind the justification for all of this. The justification is we apply the common law because the common law incorporates, in effect, best practice international law. But then he goes to 19th century decisions, which are, on any view, completely out of step with best practice international law. And as Your Honour's pointed out, my own friend's walking something of a tightrope, because, yes, he can't, once this becomes the same as English law, he's bound by Mr. Justice Burton's decision. So they have to say, well, it's somehow different from the statutory position in England. So I'll start with waiver, if I may. And the reason I start with waiver is because I'd suggest that it's just very clear, as Your Honour's pointed out, it cuts across all of the issues. And Your Honour will recall that it's often said one needs two sorts of waiver: waiver of adjudicative immunity, waiver of immunity against execution. Your Honour's been shown, and I won't go back to the bundles, but I've reproduced the relevant clauses in my skeleton arguments. One of those clauses has had citation in the English courts. That's the one which actually says the words waive and immunity. But the other one hasn't, which is the one that's contained in the arbitration agreement, whereby the KRG says that they agree that the arbitral award may be enforced in any court of competent jurisdiction. So the first, what I'll call the waiver clause, I say they're both waivers, but I'll call it waiver because it uses the word. The first has obviously been looked at by the English court, by Mr. Justice Burton, and also by Lord Justice Briggs. Yes. The second, clearly, has not, in this case, but a very, very similar court provision was looked at by Lord Collins in the NML case. And it was described, that provision, not this provision, but a very similar provision, was described as the clearest possible waiver of immunity. Now,
well, there's only one point capable of being taken, which Mr. Black has taken, which is that all has to be done according to the hell in the face of the court or by identifying the specific court. But on the face of it, we've got reference to assets, we've got reference to any court of competent jurisdiction. We've got the authority as Svenska Petroleum in relation to an arbitration clause, and in fact, as far as we've got here, before actual enforcement of recognition, that that's all within the scope of agreement to arbitration, yes. Albeit that it's, I suppose, potentially subject to the limitation of the court receipt of arbitration, but doesn't appear to be on the face of the
yes.
But you may want to deal with that. But the real point that he takes is that it's the Miguel point, isn't it?
Yes. So, there's two questions. One is, what do the clauses mean?
Yes.
And then the next question...
I don't have any difficulty with what the clauses mean.
Fine.
I don't
Well,
need you to address them.
I won't labour
I don't
that.
think Mr. Black has seen the art of the contrary.
No. So, they mean that there is a waiver of immunity in relation to assets and therefore to execution. And the issue was slightly differently put before Mr. Justice Burton and the Court of Appeal.
Yes, because they were looking at the injunction.
They were looking at the
at that
injunction.
stage, and they had a particular section of a statute to look at
Yes.
in that context. So
Yes.
Specific performance, injunction, execution. Well, at least arguably, could be seen differently. The court says, no, you can't.
Yes.
Assets covers both, and yours.
So as Your Honour says, there's just this question whether there is any specific requirement to be imposed on the way in which that agreement is made.
Yes.
For it to be effective. Is there some procedural hurdle that needs to be implemented? And the decisions that are relied on start with Miguel, but the one that perhaps if I can start with, Your Honour, is the A Company and Republic of X, because I don't think we need to go back to Miguel.
Thank you.
If we start with Bundle 1, tab 34.
Yes.
So you see the waiver clause on page 522, about halfway down on the left. Your Honour may have seen the judgment, the reference by Lord Justice Briggs to this decision, because there was a very close resemblance between the two clauses.
Yes.
The Ministry of Finance hereby waives, clause 6, that's right. You want to have that. Ministry of Finance hereby waives whatever defence it may have of sovereign immunity for itself or its property present or subsequently acquired. So it's very similar, because it's a reference to or its property. And then we see the decision on page 523, column 1 and column 2. Column 1 is the highlighted section on the left, and it has that. And then column 2, I'll just allow Your Honour to mark these up. But in column 2, it starts about halfway down the page, so you want to have particularly by its reference to property. It seems to me that the clause is clearly referring to the state immunity in respect of enforcement jurisdiction dealt with and so on. And that analysis, Lord Justice Briggs has said, was adopted in the Sava Shipyard case as well. Now, the point in this case was that there were two sorts of immunity advanced. One sort of immunity was immunity under the Vienna Convention, and in relation to that, the State Immunity Act didn't or doesn't apply. So the common law applied to those questions. And we see the decision towards the end of the page on page 524, in column 1, it's the highlighted section, it's a very short section. I agree with Mr. Jacobs that on the authorities no mere inter-parties agreement could bind the states to such a waiver, but only an undertaking or consent given to the court itself at the time when the court is asked to exercise jurisdiction over or in respect of the subject matter of the immunities. See, for example, Khan Federation. So the principle there was that you can't agree inter partes to waive immunity. And of course, just recalling, my learned friend says, well, Your Honour should apply the common law because it reflects international law, and the majority of the Hong Kong court applied this approach. And I say there are two major problems with this. The first is, as an analysis of the English common law position, it's not right, it's wrong. But secondly, by no measure can it be said to apply international law. It's wholly out of step with that. And if there is a consensus at all, this is where it is. Now, we've got two authorities which comment on this. One is by Francis Mann, and it is worth looking at because it's quite short. The other one is by Dr. Cohn, who is a German jurist, who wrote a long and celebrated article about this very topic. What I'll do is I'll take Your Honour to the Francis Mann authority. I'll just summarise what Cohn said. The Mann one is in bundle 3, tab 79. short article. There's only bits of it that I think we need to look at.
I'm so sorry, tab
79.
Thank you. Yes.
So he summarises the arguments that were made, but starts with this phrase: the arguments by the defendants, which Mr. Justice Saville rejected in A Company and Republic of X, were so obviously unfounded that one would not normally wish to comment upon the decision. Yet there are three aspects to which attention should be drawn, and then over the page he deals with the specific part I'm talking about. If you want to just read the final paragraph on that page.
So I'm straight with it because I went the whole of the Saville decision, but the argument in relation to the diplomatic privileges is by reference to the embassy and so on.
Yes. So what was happening?
The diplomatic mission.
Yes. So there was
when
an
he could
injunction.
execute on the embassy itself.
Yes. So there was an injunction which would have covered
Yes.
both the diplomatic mission and everything else. And so what Saville said was you can have the injunction in relation to everything except for the diplomatic mission, because in relation to that, you can't just agree between yourselves to waive immunity. You have to come to this court and waive immunity.
Right.
That was the position, and the cases trace themselves back to the Miguel decision.
Yes.
And that is what Francis Mann is discussing in this.
Yes.
And he refers to the Cone article, which, Your Honour, for Your Honour's note, is actually in the bundle of tab 75.
Thank you.
And the point of that was, when one looks at the Miguel case, the court wasn't actually stating a rule of international law at all. It was simply stating a rule of English procedure, which at that stage was that parties couldn't submit in advance to the jurisdiction of the English court. That's all it was doing. And what happened, and that's at page 263 of his article, which is behind tab, as I say, tab 75, if anyone wants to look it up. But what happened then, and he traces it through the genesis of that, is that that became misunderstood as a principle of international law, and then entrenched as a matter of English law as being the right approach in an international context to waiver. And that made its way all the way up to the House of Lords. And so when Mr. Justice Saville says on the authorities, he, as a matter of stare decisis, feels bound to apply that particular rule. But in fact, what had happened is that the rules had changed, and nobody had taken into account that change.
In 1920?
In 1920, quite. And that is what Lord Collins explains in the NML case. Your Honour was taken again to some of that, but not all of it. Is it helpful to go back to it and just?
I think it may be just.
And Lord Phillips deals with it as well, but it's quite helpful. If we go back to tab 63 in the same bundle. We start. So it's the same. We start at the same place as my learned friends.
Yes.
So he asked you to read to
125. Yes.
That's right. So that is a summary of the development of that rule of English law. One can't really call it a rule of common law as such, any broader than simply it's a rule to which courts below the Supreme Court or the House of Lords were bound by stare decisis. It's not incorporated into the common law as such in the way that would be required to justify its introduction here. But if we go, so there's a reference to 125 then to the Francis Mann, Dr. Mann's article, and recites that, refers to the Cone article, and says, in a classic article, Cone showed that from the 19th century, civil law countries had accepted that sovereign immunity could be waived by a contractual provision, and that the speeches in Duff Development on the point were obiter and did not constitute a majority, and that both Duff Development and Kahan had overlooked the fact that submission in the face of the court was not the only form of valid submission since the introduction in 1920 or the rule that the English court would have jurisdiction to entertain an action where there was a contractual submission. In particular, in Duff Development, Lord Sumner had overlooked the fact that British Wagon Code and Grey was no longer good law. And then he doesn't say the common law was changed by the Sovereign Immunity Act, State Immunity Act. He says the principle enunciated in Kahan and Pakistan Federation was reversed by Section 2.2 of the 1978 Act, which provided that a state could submit to the jurisdiction by a prior written agreement. This is consistent with international practice. United States Foreign Sovereign Immunities Act and so on, and expressly refers to, over the page, the UN Convention on the Jurisdictional Immunities of States and their Property. So the rules for submission changed, the authorities hadn't moved on, English courts were bound by stare decisis, and if you're bound to apply English law, then, prior to the 1978 Act, or in circumstances where the 1978 Act didn't apply, such as was the case for Mr. Justice Saville, you would have had to find that there needed to be a prior express agreement. Now, what Lord Collins is saying is actually that was never right, and anyway it's been reversed in statute. And anyway, it was always out of step, as Francis Mann says, with international practice. And it's just worth pointing out that, as far as I can tell, the Hong Kong decision doesn't refer to the NML case. It may well be that it wasn't available to them. I think they were both decided in 2011. But the minority, there was a 3-2 decision on this issue, and the minority went with Francis Mann's approach. And certainly Lady Fox thinks that there has been an amendment to what we would call the common law, or that the common law has been explained in accordance with this, and one finds that at page 379 of her textbook. It's behind tab 85. So, but anyway, one comes back to the point that it's the justification for importing the so-called common law.
Well, let's just be clear about where this gets us to on your submission.
Yes.
Prior to the 1978 Act, immediately prior to it, one would have to accept that English
law, yes,
was as per Miguel.
Right.
Well, that's the question.
Yes.
Paragraph 125 doesn't go far as to say that that was not English law at that stage, does it? As I read it.
No, I think
that's what is being
because,
said is that
yes,
English law took a wrong turn. It was wrong. That's what he's actually saying.
I think,
unfortunately, he's tried to say that.
yes,
Not only because he's in the Supreme Court and House of Lords, but because statute law has changed its position anyway.
yes. I think what he says is that the point was obiter and Duff,
Yes.
but it's picked up in Kahan,
Which
and then that's going to bind, as a matter of English law,
exactly.
subordinate courts.
You've got Court of Appeal
Yes.
authority.
Yes.
So it has misunderstood Duff.
That's right. Save that. There is no. I mean, the way I would argue it if I was in the English court before 1975 would be to say, actually, principles of international law do not know a principle of stare decisis. So if this is a principle of international law, we're told in plain text that the law of England just changes by incorporation. That was the major issue in Trentex.
Well, I see that.
Yes. So as international law develops, so changes English law. So if the position was stated to be in England that international law requires that there's submission in the face of the court, and that is why we're incorporating it, then there is a good argument to say actually it's wrongly decided and it's open to a junior court. And that, I suppose, is why Dr. Mann took such exception to Mr. Justice Savile's decision, albeit, as he pointed out, it was a very minor point, a minor part of the issues in that case, because they weren't too worried about diplomatic premises, they were more worried about the rest of the assets.
So again, to be clear about your submission,
yes,
it would be that immediately prior to the passing of the 1978 Act, customary international law has moved on, and as a matter of English law, Caharan, Court of Appeal Authority in 1941, was no longer binding, and the true position is as per F.A. Mann.
That would be my submission to the English courts, and I can see why they would have scepticism of it, given that a senior court had just 25 years before decided that I was wrong on the point, albeit it would be open to me to take that argument. It would, I suggest, be open on the principles of the way in which English law incorporates international law. So actually, English law it is what it is. Insofar as it incorporates international law, it just is international law. So if that is the way that this particular principle has been understood to be incorporated into English law, then at any point somebody could turn around and say that's wrong. Now, but I can see that it would be met with scepticism, given that it's been decided 25 years earlier, and I'm coming to the court saying nothing has changed in international law to make this change. But now, what we have is a much broader consensus to show that it's just out of step, it's not international law. So that is why it's important that Cohn says, the sort of centrepiece of his argument, is to say, well, actually Miguel doesn't state a principle of international law at all, but it becomes understood as a principle of international law. Anyway, happily, I don't have to appear in front of the Court of Appeal in England in 1958 to try to argue the point, but the point for Your Honour's purposes...
Well, there's not much doubt that life had moved on between 1951 and 1978 in this context.
I think pardon?
There's not much doubt that life had moved on between 1951 and 1978 in any event in this context. There are a number of cases flying around in this sort of area, as Trentex itself shows.
Yes, yes. So, and as perhaps,
what date was Trentex?
So perhaps the 1978 Act shows.
What date was Trentex?
75. I think that's right. 77.
77. All right, but there you are. And by that stage, you can see how life had moved on.
Yeah. So I think it would be open, and hence the criticism of Mr. Justice Savile's decision, because if he was simply bound by stare decisis, which is the way he put it, he says on the authorities there has to be this submission to the court. He doesn't look at the question any more deeply than that. So it seems to me that in front of Mr. Justice Savile there would have been an argument that actually the state of English law is now different. Even if that was right, the state of English law is now different. You don't need submission to the court. You can have an inter partes agreement. But for the purpose of this court, it seems to me one has to look at why we are importing these principles if we are. Why would a modern court, or a modern jurisdiction, because if we're dealing with the whole of the UAE, why would it decide to pluck this particular dead end in English jurisprudence, which is out of step with international law, and decide that that is the right way, that's the right test for waiver?
Why would it want to apply a dark argument?
Yeah. And so Your Honour doesn't have to take it from me, you can take it from Francis Mann, Dr. Cooke, Lord Collins, and indeed many others. to see that it's just not, there can't be a justification for restricting this principle in this way. While we're in this case, Your Honour, I was going to show the way in which the House of Lords dealt with a very similar waiver provision to the one that is contained in the arbitration agreement, and it's just the next two paragraphs we see at 127 and 128.
Thank you.
Lord Phillips deals with that provision as well at page 518 in paragraphs 55, 57, 58 and 59. But I would just ask you all just to look at that page, the top paragraph on that page, 518, then paragraph 57, and then 58 and 59.
Yeah.
So it's both a submission to the jurisdiction and a waiver. And it's a submission to any court of competent jurisdiction. And that is a question. The question of competent jurisdiction is a question to be answered by reference to the rules of the particular court. That was the same approach that Lord Collins took. So Lord Collins and Lord Phillips are saying, because our rules give us jurisdiction to enforce foreign judgments, we are courts of competent jurisdiction within the meaning of the clause.
Yeah.
And I'd say that they both confirm that there's no particular magic in the State Immunity Act. They simply confirm that this artificial restriction on the structure of a waiver agreement should never have been applied. Certainly isn't a feature of international law. They also make the point that the meaning of the clause, so the interpretation of the clause is a matter of the law of the agreement, which must be right. And as we know, the clauses the waiver clause at least has been interpreted as covering everything. And the issue was to injunctions, but within that, the sub-issue was, does it cover enforcement and indeed adjudication, and on any sensible construction, in other words, Mr. Justice Burton, it must cover at least those. So that's where we are for that. It's now 4:45. Is that a convenient moment?
Indeed. Right. Thank you. 10 o'clock tomorrow. Very much.
All right.